reverse engineering of software, what and why, and some of the issues surrounding software reverse engineering. We're then going to turn it over to Woody Pollock, our guest speaker from Gray Robinson, who is going to discuss the legal aspects of reverse engineering. And then we'll open it up for questions and answers. We hope that you will submit your questions in the question box, and we will answer them at the end of the talk. So I'm Jim Adams. I got my PhD in electrical engineering at the University of Nebraska, and I've been with TAEUS for the past 21 years, doing reverse engineering of hardware, software, systems, portfolio mining, patent evaluation, etc., in support of the intellectual property licensing. During the last 21 years, I've been a testifying expert in patent, copyright, and trade secret cases. And before TAEUS, I worked in the microelectronics industry at Sandia National Labs, InMOS, Monolithic Memories, and United Technologies. So these are the topics that we're going to cover today. I'll be covering the first four, and then I'm going to turn it over to Woody to discuss the legal aspects of reverse engineering. This is what we would like you to take away from the seminar today. What is reverse engineering? Why do we reverse engineer software? What are the primary types of software reverse engineering? What it is that we analyze, when it's legal and when it's not legal. So what is reverse engineering? Reverse engineering is the process of discovering the technical principles of a device, object, or system through the analysis of its function, structure, and operation. Everybody does a bit of reverse engineering in their everyday life, whether it's figuring out how to use your TV remote control, running applications on your smartphone, or diagnosing a problem with your car. You're discovering the technological principles of the system. There may or may not be enough documentation to allow you to figure out how it works without doing some tests. And it may be more complex than you want to tackle, so you take it to an expert. Is it worth it? When you're protecting your intellectual property rights and patents, copyrights, and trade secrets, you need to consider the return on investment. Is somebody taking some of your market share, or is it just an emotional situation? It can cost as much to reverse engineer a piece of software as it did to create it originally. The benchmark is 2 to 15 lines of code per hour. Therefore, if you're going to do it, it needs to be very targeted if you're going to use a brute force approach. We'll talk more about that a little later in the presentation. Now, these are the primary reasons for doing reverse engineering. The first three, identifying potential patent infringement, copyright infringement, and misappropriation of trade secrets, is where we do most of our work. Although we have worked in the interoperability arena as the technical expert for the European Commission in their antitrust suit against Microsoft. In that case, they were looking to make software interoperable, and we were doing investigations into how easy that actually was. It's also one of the areas that is explicitly built into the Digital Millennium Copyright Act. And a section is written into the law to allow for circumvention of copy protection and other digital rights management in order to reverse engineer the code for building interoperable programs. Failure analysis, obsolete parts replacement, and specification update and correction kind of go together. This is done when you might have to debug a piece of code that is broken, get code reconverted from an older language to a newer language for updating purposes, or if your programmer has left the company and he didn't adequately document the code, it may be necessary to reverse engineer the code to figure out how it works so that you can document it appropriately. We also do software reverse engineering for competitive technical intelligence to help estimate manufacturing costs. And the last point here of security auditing, it's worth spending just a minute to talk about this. The government has spent a significant amount of money developing reverse engineering capabilities to look for counterfeit hardware, particularly integrated circuit chips, and to assure themselves that they're not getting back doors built into either hardware or software that could compromise security. The three red boxes at the bottom talk about more nefarious purposes for reverse engineering, and we avoid getting into these. We will analyze code and do circumvention of access restrictions only with a written permission from counsel. These are types of software reverse engineering that are typically done. There may be a construction analysis of the structure of the code. In particular, this involves developing a flow chart, looking for the high-level structure of the code itself. We may do a function analysis on how it works, and that generally involves looking at a very narrow subroutine and or extraction of a particular algorithm or formula from the code to identify whether it's performing a particular function. A large part of our work is done in black box testing. Stimulus response. We'll build custom inputs, may even write custom code to generate inputs for the software. Now this does not involve disassembly or other access to the code itself. It's using it in its normal environment, but we will look at how a particular function is performed. For example, taking a picture of a custom design test pattern and then analyzing the resultant image can tell us a lot about how the image processing software is done. In software reverse engineering, we do custom analysis of software, algorithm extraction, look and feel analysis, and copyright and trade secret analysis. And I talked about the interoperability and compliance analyses. These are the things that we analyze. We'll look at source code, object code of programs that run on a normal computer. We'll look at firmware. such as code that is in a flash memory or a ROM, but more often the code is embedded in a microcontroller or microprocessor. Sometimes it's totally invisible or marginally visible, such as in the case of an operating system in a smartphone. We'll look at hardware, reverse engineering of the code while it is operating and looking at how, for example, a data bus behaves under certain inputs to the code. We'll also analyze packets that have been created by different types of software. And each one of these analyses presents unique challenges. You have to organize the problem to develop the most cost-effective solution for analysis in each particular case. Some of the challenges that you face in doing this are the size and complexity of isolating the code of interest. In the case of big programs, there may be megabytes of code. But the code of interest, where we're trying to identify an infringing implementation, may be on the order of a few bytes or a few kilobytes out of the total piece of software. It's necessary to break it down and to pull out things that are what we would call standardized subroutines and functions that get embedded as part of the assembly language oftentimes. You have to take into account interaction with code or hardware. Software rarely runs on its own. There are libraries that it draws on, and it requires input from hardware in order to work properly. One particular example of that is the case that we worked on that involved infringement of our client's patent on how to determine if a fish should be displayed from a side-looking sonar. We call this the fish finder case. It was Computrol versus Lowrance. Our client had performed some black box testing on a competitor's fish finder and determined that it was likely that the competitor had reverse engineered their fish finder and incorporated their algorithm for determining when to display a fish on the display of the sonar. They filed the lawsuit and received 5 boxes of redacted assembly language code as a result of the discovery order. The law firm came to us to analyze the code. Needless to say, thousands of pages of redacted assembly code is practically worthless. We went out, bought a fish finder, dumped the embedded firmware from the TI digital signal processing chip, and reverse engineered the printed wiring board to determine the sources of the inputs to the DSP chip. We then analyzed the operation of the code largely by hand over about a 2-week period and determined that indeed the method that was covered by the patent of our client was being used. As a result, the case settled out of court before going to trial. Now I'd like to take just a minute to talk about the differences between source code and object code. Source code is human readable instructions such as Fortran, C, VHDL, Perl, and even assembler can be considered to be source code. It is readable and understandable based on documentation of how instructions are supposed to perform. Object code is binary ones and zeros that together with the microcode in a microprocessor tells the microprocessor how to twiddle the bits. It isn't possible to reproduce the original source code directly from object code. You can disassemble the object code. You can, in some cases, decompile the assembly language code and get back to a form of source code, but it won't have the comments, and it won't be structured the same, depending on the level of compiler optimization. It's likely to be very different from the original. Often, black box testing is sufficient to get to discovery, and then a Rule 34 inspection will allow examination of the original source code. This examination often has to be done by an expert in a secure facility under a protective order. And I think Woody will talk a little bit more about that in his presentation. Some of the challenges of analyzing embedded firmware include either poor or non-existent documentation. It's rare to have documentation on embedded code. Now, for example, most of the BIOS in your laptop, when it does a power on self-test, it isn't documented at all. The other documentation may be poor, or you can only get it through a non-disclosure agreement. Firmware typically doesn't have a EULA associated with it, and it may or may not be copyright protected. Woody will talk about those issues when we get to his presentation. But firmware can be difficult to debug. Are we still in? Can people hear? If you can't hear, send a message. Okay, wonderful, thank you. We were concerned the sound might have cut out. A kernel debugger can be used in some cases, depending on how it works. A kernel debugger is software that's built into an operating system for the purpose of debugging applications that depend on an operating system. Windows NT, Unix, BSD, Linux, and OS X all have kernel debuggers. But other things, such as cell phones, may not. And so it's necessary to set up emulators or other specialized tools in order to analyze firmware. We'll talk more about that and how we go about doing it in our next webinar. In summary, almost anything can be reverse engineered given enough time and money. The question is it worth it? Is there a return on your investment? When you consider this question, don't assume that a brute force approach is necessary. Experience is the key to dealing with different kinds of software reverse engineering challenges. That will get you the most cost-effective solution. So, in our next webinar, we'll discuss the tools, techniques, and case studies. And we hope you will join us. Now I'm going to turn it over to Woody Pollock, who's a shareholder of Gray Robinson. I'll let him introduce himself and then move on into his presentation.
Okay, Woody, you're on.
Okay, thank you. And thank you, TAEUS, for setting this up and inviting me to present some of the legal issues involved in reverse engineering. As the slide in front of you says, I'm Woody Pollock. I'm a shareholder at Gray Robinson, a Florida law firm. My practice is in Tampa, Florida. By way of brief background, law for me is a second career. I got a master's degree in computer science from Stanford and then worked in Silicon Valley as a software engineer for a while before seeing the light or seeing the dark, depending on your perspective, and deciding I wanted to become a lawyer. And now what I do is I'm a patent lawyer and I'm board certified by the Florida Bar in intellectual property. And so I devote my practice exclusively to intellectual property and spend the majority of my time dealing with litigation-related issues concerning software. I think Maria and Jim, you guys still have control. If you can go to the next slide. From a high-level view, the main IP issues that come into play when you're dealing with reverse engineering of software are patent law, copyright law, and trade secret law. And it's important, and then is also contract law, which we'll talk about in a moment, but it's important to keep these different bodies of law separate and understand what their objectives and what they're designed to protect. Patent law exists to protect inventions that are new, useful, and non-obvious, and software can include many patented features within it. Copyright law protects expressions of ideas as opposed to the ideas themselves, and that's a key issue, particularly as it relates to copyright infringement of software and reverse engineering of software and wanting to avoid liability yourself for claims of copyright infringement if you're the one who's reverse engineering a piece of software. And then trade secret, as the name suggests, protects things that are secret and derive value from them being secret. And the standard example I like to provide is think of a recipe for chicken at Kentucky Fried Chicken, or a recipe for Coca-Cola. Those are valuable trade secrets of their respective owners that derive value from the fact that others don't know them. So let's dig into a little bit of the details if we can go to the next slide. Like I mentioned, my practice is in Florida, and we're going to start with trade secret issues. Trade secret is governed by state law. It's a creature of state law, and each of the states has adopted its own law for what to do with trade secrets and how to protect them. Florida and Colorado, as we'll see in a moment, have implemented the Uniform Trade Secret Act. And as I said, the key pieces, which are shown here in the bold and underlined font, are what a trade secret is something that derives independent economic value and is subject to efforts that are reasonable to maintain its secrecy. So if you've got a feature, an algorithm, a component that is important to your business, and you derive economic value from it, and you don't tell other people what it is, and you subject those that know it to confidentiality obligations, well, then you've got some trade secret protection at play. If we go to the next slide, I know that TAEUS is in Colorado. I've spent a fair amount of time in their lovely conference rooms looking out at the Air Force Academy. The Colorado statutes, written differently, but essentially the same components. It protects trade secrets, which are things that are secret and of value. Now, misappropriation of a trade secret is when someone uses improper means to acquire a trade secret or something that is secret and of value to another. And this is potentially at play when doing reverse engineering, and something to be aware of, because the penalties for this are not just civil issues where the owner of the trade secret could pursue someone for a claim of misappropriation. But if we go to the next slide, there's also criminal penalties under the Economic Espionage Act, including what I would describe as a pretty significant penalty if the misappropriation of a trade secret that you're engaging in is to benefit a foreign government. As you can see from the slide, the penalty can be up to $10 million and a 15-year federal prison sentence, which is a pretty hefty stick, I'd imagine, to swing. And even still, if you're not even trying to help a foreign government, the commercial purposes penalties listed in the second point below are not inconsequential. So that's a little bit scary to hear. Reverse engineering, by definition, if you're trying to figure out how a piece of software works, someone could always argue that what's in that software is a trade secret, and if you do that, you don't want to be on the hook each and every time for these criminal and other civil liabilities. So what to do with that? Fortunately, in the mid-1970s, the Supreme Court added some guidance here, and if we can go to the next slide, there we are, made clear that these state trade secret laws don't prevent essentially fair use activity, which is figuring out how things work using honest and fair means, including by what the Supreme Court called so-called reverse engineering. So this was good and a good time to be in the business of reverse engineering, particularly for the next 20 years. Essentially, the Supreme Court embraced a fair use defense to a claim that you were violating somebody's IP in the form of a trade secret. Now, something I always tell people when you're dealing with IP, whenever you hear the words fair use, you should, tread carefully, because fair use at the end of the day is a defense to a claim, meaning that if somebody wants to pursue that claim, the fair use argument doesn't necessarily get you out of it. It just gives you something to argue about in court. And as you are likely well aware, fighting about these types of IP issues can be extremely expensive. So it's always better to be in a position where you avoid a liability as opposed to having a defense for it, saying, well, I did it, but it's okay because it's a fair use. So thinking back to this, what I'll call the heyday of reverse engineering, the 70s to 90s, the software companies, they had lots of trade secrets in their software products and would rather people not dig into them because they, as Jim mentioned, it's expensive to both build software and it's expensive to reverse engineer software. So to protect those innovations, the software companies, like many others, started adding contractual restrictions to limit what you can do when you buy or license a piece of software. These issues are all governed by state contract law. And here on the screen in front of you, we've got the End User License Agreement, or EULA, from Google Chrome, the web browser. And when you download and install and start to use that web browser, you are agreeing to a contract. And one of the terms you have agreed to is that you will not reverse engineer, decompile, or otherwise attempt to extract the source code of the software or any part thereof. Going to the next slide, just by way of further example, Apple has the same types of restrictions through its App Store. If we can get to the next slide. There we go. Whoop, we went one too far. The point of the App Store EULA is the same thing, which limits you from reverse engineering, disassembling, attempting to derive the source code of. And what's interesting here is it's not just of the App Store software itself, but the licensed applications, which are the apps that you download. This is interesting and important because if one of these entities that owned a piece of software, let's say Google, and you went and tried to disassemble or reverse engineer Chrome, they could make an argument that that is a breach of your license agreement with them, the EULA that you agreed to when you downloaded and installed that software. Now, that was well and good under the 1974 timeframe, where so-called reverse engineering was granted permission and escaped from trade secret protection, because the courts mostly found that contract restrictions like what are in front of you wouldn't be upheld because they were violating this fundamental right to be able to engage in this fair use type activity. And so if we go to the next slide, the question that becomes presented is a misappropriation of a trade secret is when a trade secret is acquired through improper means. So the question is, if you breach a EULA, which is you do not honor your obligation to not reverse engineer, and so you figure out whatever the trade secret is embodied in that software, have you now engaged in improper means of acquiring it and thus subjected yourself to liability? Before we dig into the answer to that question, let's bring copyright law into play because it kind of helps to change the answer a little bit. Copyright law, as I mentioned a couple of minutes ago, deals with the protection of the expression of ideas as opposed to the ideas themselves. In the literary context, the example I always give is you can protect a novel about a boy meets girl, they fall in love and live happily ever after. Your expression of that idea is certainly protectable, but that idea itself is not. The same thing applies to source code. The idea of having a word processor, that is not a copyright protectable idea. But your implementation probably is, as long as what you've done satisfies what the Copyright Office calls a modicum of originality, which is to say it's something at least a little bit original. Maybe not just a standard for loop for looping through particular things, but the way you select and lay out your source code certainly would be subjected to copyright protection. So let's, and before we turn to the next slide, copyright, like many other IP law areas, has a fair use defense. But again, that's a defense to a claim, meaning you're in a federal district court in front of a federal judge saying, yes, I did commit copyright infringement, but that's okay because of all these other reasons. If we go to the next slide, the end of the heyday of reverse engineering, maybe that's not the best way to describe it, but in 1998, Congress passed the Digital Millennium Copyright Act, which imposed some penalties and tightened down people's activities aimed at circumventing technological measures for protecting computer stuff and copyrighted works. And within those changes, on the next slide, we'll see that there was an exception to those restrictions made for reverse engineering. So on its face, that's good. We've carved out reverse engineering as a viable and okay thing to do. But the concern is that the reasons reverse engineering have been allowed under the DMCA have been restricted. What I didn't mention earlier in talking about the 1974 time period was that essentially if you were engaged in reverse engineering for, quote, a legitimate purpose, then you are okay. And the bounds of what a legitimate purpose are pretty broad. As long as you weren't looking to sell a knockoff version of something, you were mostly in the clear. As we can see from the bold-faced language in the DMCA in front of you now the acceptable types of reverse engineering are those that are for the sole purpose of identifying and analyzing those elements of the program necessary for interoperability of an independently created computer program. So if we go to the next slide, we can see that whatever the scope of what those words mean, it certainly is more narrow than just the legitimate purpose scope that used to be the test beforehand. I'm sorry, if we can, there we go. So prior to the DMCA, as long as what you were doing was a, quote, legitimate purpose, you were pretty much okay. After the DMCA, at least under copyright law concepts, now you have less of a safe harbor. And instead, if you weren't building a separate computer program and just investigating the other computer program for interoperability issues, you might have some concerns. This is concerning on some level and certainly represents a little bit of an unsettling area of the law. And there have been cases since the DMCA was issued where a restriction against reverse engineering in a EULA was found to not apply, where the judge said, well, you signed up to a EULA, and by doing that, you waived any fair use defense you might have had, because the logic and policy behind that view was private parties can contract to do anything they want. I can build a piece of software and say, I will only let you use my piece of software if you agree to never try and circumvent the protections I put in that, including never try to reverse engineer it. If you continue to use that, you've agreed to those terms, and we've got an agreement. Now, the fact that we didn't sit down and negotiate that agreement and each sign on the dotted line, from a contract law standpoint, really doesn't matter, so long as the agreement is not unconscionable. And most of these EULAs will likely hold up under that type of analysis. So what do you do? Normally, these types of investigations happen, as Jim mentioned, in the context of a copyright or a patent or a trade secret complaint or potential litigation or actual litigation, which eventually will likely head to actual litigation. And if we go to the next slide, there's ways within the litigation to be able to do this reverse engineering, certainly without the concerns of all the law I just went through. But the way that that is done is the parties usually negotiate. Sometimes they agree, sometimes they don't, but the court will eventually enter a protective order where two main components will be at issue for purposes of this talk. One is a patent prosecution bar, and the second is the logistics of how the source code will be made available. Concerning the patent prosecution bar, these have become relatively common in source code protective orders, because at the end of the day, one party is making its crown jewels available to another party, likely a hostile adversary, and they have a concern that they don't want that other party's experts to come in, look through the crown jewels, and then go and work for another competitor in the field and file a whole bunch of patent applications based upon the knowledge that they obtained by thumbing through all this crown jewel information. And so those patent prosecution bars usually limit that activity for a period of time, at least through the litigation, usually a little while after, and so long as the expert doesn't end up being employed by one of the competing parties. Another sub-issue there is that rule generally applies to regular patent prosecution activity, which is the act of, obtaining new patents on new inventions. Carve-outs have been done here for what I describe as post-grant proceedings, which are when a party brings a patent back to the patent office in an attempt to invalidate the patent through some post-grant activity, a re-examination or inter-parties re-exam or other activity where you can't add to the scope of the patent. You can really only adjust the validity of the issued claims. The second bullet point on this slide is the logistics of source code production, and that usually depends on how much effort and time the parties want to spend in protecting it. Sometimes they'll allow it to be produced at one of the council's offices. Usually they will require some type of third-party escrow safe room where you have to sign in and sign out, and you're limited what you can bring in. I've seen them where you can bring in a computer and take notes. I've seen them when you can only bring in a pad and a pencil, sometimes even less. And that's really just a question of what the parties are willing to agree to and what level of comfort they have with the various different options. The last bullet point on this slide is just what happens at trial. Everything we've talked about previously is usually taking place during discovery when everything can be maintained confidentially. But when it comes time for trial, courtrooms are generally open forums for the public to come and see, and that butts up against these confidentiality concerns. Now, courtrooms can be closed to protect trade secrets, but usually judges don't like to do that. And so usually there's some logistics or some information in place, usually in those protective orders, to say when we do get to trial, here's what we're going to do, here's how we're going to have you, Mr. or Miss Expert, show these various components of the source code so that we can still maintain whatever trade secret or protected information is there, while at the same time accomplishing our goal as a public forum in which to have disputes. So from a legal side, that's the extent of what I have. I appreciate TAEUS letting me speak on this topic, and I look forward to answering your questions.
I hit the wrong one.
Hello? Can you hear us?
Hello?
We can hear you.
Okay, good. All right. Well, we'd like to thank Woody for taking the time to do this presentation. Hopefully you've gotten something out of it and have gotten an understanding that software analysis can be quite challenging. Often it's quite valuable to a client, and it can be legal for the right reasons. You just have to be very careful and understand the ramifications of what you're doing. So now we'd like to take any of your questions. If you just type them into the box, we'd be happy to answer them for you. If not,
Oh, here's a question.
yeah, here's a question that came up. While going to all the work of decompiling does not yield accurate original source code, does it yield accurate source code? Well, yes, you can decompile certain types of assembler into a source code. It will be accurate in terms of reproducing the function. It may not be the same as the original, but it should reproduce the same function. Okay, here's another question. Is software reverse engineering okay for infringement analysis in light of the restrictions of the DMCA? I'll let Woody take that one.
I'll give the great lawyer answer, which is it depends. That's going to depend partly on what's in the EULA. If the EULA has no restrictions on reverse engineering, then probably you're okay. If it does have strong restrictions on reverse engineering, that could be problematic because, as I mentioned, those types of restrictions have been upheld. What we have done, or in some circumstances have done, is reached out to a potential defendant to say, look, we want to look at your code, but we don't want to violate any of the contractual provisions or otherwise. Can you give us a copy that we're allowed to poke around on? Usually they say no, but then that puts you in a position where you can go to court and use the tools available to you in court, namely discovery, to do the investigation while maintaining your obligations to pursue a litigation and also avoiding violating any DMCA or EULA reverse engineering restrictions.
Good. All right. Another question is, would copyright issues go away if the reverse engineering was done internationally? I'll let Woody take that one also.
Thank you, Jim. Another good question. Copyright law is a national law. Every country has its own law. The United States, the DMCA was actually implemented in part to bring us in line with certain other international countries. There would be means if the circumvention was done in a manner that violated the DMCA, but the circumvention was done outside the United States for the purpose of bringing it into the United States. Presumably, there would be a way to interfere with and obstruct that behavior. If you were the rights owner and someone had knocked you off in another country and then tried to bring that in, you'd be able to use portions of the Copyright Act to interfere with that. So that wouldn't be a blanket freebie just if the work was done outside the bounds of the country.
Okay, thank you. Here's another one. Does reverse engineering and creating a design-around piece of software cause the software to be a derivative work? Well, if you're analyzing software to create interoperable or equivalent software, and you want to keep the development clean, you really need to do it in what's called a clean room environment. You have two teams of people. One that is reverse engineering the code of interest and writing a specification for how the code works. And then an entirely separate team that has no access at all to the original code, and based on the specifications that are developed by the first group, they will create a totally independent piece of software code such that it is a entirely new work, in which case I don't believe it would be considered to be a derivative work because it doesn't include any of the original software. If you were to take portions of the original code, you could be liable both for potential copyright infringement as well as creating a derivative work. Okay. Here's another question. For digital forensic investigation, there would be some frameworks. Is there any generally accepted legal framework available for reverse engineering? I would generally say yes, but I'll let Woody talk to that first.
Well, I think yes. The question would be for what purpose? If for a nefarious purpose, then no. If for determining interoperability, you want to talk to a protocol that's out there, you're probably okay, although there is case law where post-DMCA, someone attempted to just sniff a network to figure out the protocol that was being talked by a gaming system so that they could build additional gaming apps. And that was found problematic, and they were liable and can no longer maintain that, not because of DMCA issues, but because of the EULA that said you can't reverse engineer, and they had violated that. So if it was just for interoperability, you're probably okay. If it's in the middle, I don't have a better answer from a framework other than look at the EULA to say what is and is not allowed, and then ask for permission.
Yeah. Basically, it depends. Are there any other questions from anyone? If not, we hope the presentation was informative, and we look forward to you joining our next seminar in October on the 23rd. We'll be emailing out links to the registration soon. The presentation will be posted on our website tomorrow, and so we thank you again very much for the time you've taken to sit in on this webinar. Woody, thank you again for your participation. We know it's late for you. And everyone, have a good evening, or a good morning in the case of those who have joined from Japan or Asia.
Thank you all.